is Cheryl Williams, and I am a juror in the case of Elizabeth Thompson versus AU Hospital. In this case, Miss Elizabeth Thompson was a patient and has been a patient for 10 years with AU Hospital. In fact, it was for over 10 years for AU Hospital until her privacy and trust were violated. According to Ms. Thompson, the hospital disclosed her information without her informed consent. AU Hospital received a petition from an outside party needing Miss Elizabeth Thompson health information. She was not aware of this situation. She was not aware that this third party needed her information. And the reason why she feels violated is because they disclosed her private health information without letting her know that they were going to be disclosing her information. She was not aware of the fact that they were trying to get in touch with her, and in her um, statements, she's saying that they could have contacted her several ways. They could have emailed her, they could have sent her a certified letter, and of course, you know, when you send a certified letter, that someone have to sign for the certified letter, and that lets you know that the information was received, because once you sign for that letter, then it documents when and who signed for the certified letter. Also, they could have called her by phone, but according to Ms. Thompson, she was not informed at all about the situation. She felt that she was violated because she felt that she has a personal relationship with them because she's been with the hospital for 10 years. She felt that someone could have really done more to contact her and let her know that her information was needed. Of course, she was not aware that this outside party needed her information. Um, Under the HIPAA Act, if an entity has a subpoena, they would have to have a court order subpoena. Um, in this case, when they needed the information, of course, we know they should have contacted her and they didn't. But so she feel like of course, again, she feel like she was violated. Okay, according to her, all of her demographic information was current in their system. Demographic information meaning name, telephone number, email address, and their pertinent information like that. And this is the information that the hospital receives upon arrival of the patient. They have to get the demographic information to include insurance information, like I said, telephone number and name, and this information is given when the patient arrives at the hospital. And if her information is current according to her, and if her information was updated in the system, then they should have had several ways to get in touch with her if the information was current. According to the CDC, all patients are to receive notices of privacy clearances when they first arrive to the hospital. The notices are to be in plain language and clearly posted. Certain covered entities must make a good faith effort to obtain an individual's acknowledgement of receipt of this notice. It may even be provided electronically. A HIPAA covered provider may disclose information to a party issuing a subpoena only if the notification requirements of the privacy rule are met. Before responding to the subpoena, the provider should receive evidence that there was reasonable efforts to notify the person who in this case was Ms. Elizabeth Thompson, who is the patient in this case. And she should have been notified that her information was needed. And that gives her a chance to agree or not to agree to disclose her information. In this case, she was not, according to her, she was not notified, so she felt that she was violated. And I must say that after listening to this case and reading about this case, I think I feel the same way. Also, I think I would feel that my rights were also violated if they did not make a good faith effort to get in touch with me. She felt that she had a personal relationship with the hospital because she's known them and dealt with them for over 10 years. There's a business side and then there's the personal side in dealing with patients. And in this case, she felt that she was violated and she felt that she took it more personally than she took it from a business angle. She felt that she should have been dealt with more on a personal angle. And like I said, I can see why she would feel this way. So in this case, I'm going to go with the plaintiff. I feel that she was correct in feeling how she felt, and I felt that she should have been dealt with on a more personal level. And if she said she wasn't contacted, I feel that they should have made more of a better effort to contact her before giving out her information to this third party. Again, this is Cheryl Williams. I'm a juror in the case for AU Hospital court case. Thank you.